Mr. Rogers, my name is Judge Payton, and this will serve as your bond hearing. The purpose of the hearing is for me to inform you of your rights, the nature of your charges, and to set your bond. Before we get started, you have the right to remain silent, so anything that you state in here can be used in any future hearings or trials, as everything here is recorded as evidenced by the red light above. You also have the right to an attorney. If you cannot afford an attorney, you have the right to have one appointed to you. If you wish to be screened for appointment of an attorney, if you're released, that process is done at the Greenville County Courthouse through the Public Defender's Office. If you're not released, that process is done here at the jail. You also have a right to a trial by a judge or a jury. And it's your right and obligation to appear at any trial that's scheduled for you on these charges. Failure to appear for a trial could result in an additional criminal charge being lodged against you. Failure to appear for a trial on a felony carries a penalty of 5 years and $5,000. You've been charged with a general sessions or a circuit court level charge, which means that you're entitled to a preliminary hearing. So at the preliminary hearing, the state presents any evidence that they have against you to a judge, and the judge at that time will determine if the state has enough evidence to continue to move forward against you. If you wish to have a preliminary hearing, then that request has to be made within 10 days. If you fail to make that request within 10 days, then you lose your right to the preliminary hearing. And if for any reason these charges are dismissed, not prosecuted, or you're found not guilty, then you have a right to have these charges expunged or removed from your criminal history. And lastly, it's your responsibility to keep the court abreast of any changes which may occur with your contact information, as that's the only way for us to inform you of court dates, trial dates, or other information. So if your contact information changes and you do not update the court, you will still be held accountable or responsible for any notices that go to old or changed addresses. So everything that I've just gone over, you'll receive on your paperwork at the end of this hearing, so you'll have this information at your fingertips, and you'll be asked to sign and initial, confirming that you received this information both verbally and in writing. All right, Mr. Rogers, you've been charged with murder and possession of a weapon during the commission of a violent crime. Murder is a felony which carries a maximum penalty of between 30 years and life. Possession of a weapon during a violent crime is a felony which carries a maximum penalty of 5 years incarceration. Is there anybody from the family who would like to say anything or address me in any way?
I'm Antwanaza Rogers' mother. I don't feel like he need a bond. I don't feel like he need to be released. He took my one and only child away from me. He took the mother of his child away from him. He had every opportunity to leave my daughter and let her be. But he chose to take my daughter's life. So I don't feel like he need no life out here in the streets. Period. If he was any type of man, if he would have been any type of man, any type of husband, any type of a father, any type of a human being, he would have walked away from the situation and let it be. But he premeditated this thing. I can't see my daughter for the rest of my life. He don't have a life either.
All right, Mr. Rogers, at this time, I'm going to deny your bond. The circuit court will notify you of the date and time that they will have a bond hearing if they choose to have one. They set their own docket, so again, they'll give you that notification to the jail. Do you have any questions, issues, or concerns?
No, sir.
All right. Mr. Rogers, my clerk will have some paperwork for you to sign at that window to your left.